Francis Muruateru and Wilson Wanga may be heading back to the place they have called home for the last 14 years, but they do so with renewed hope that freedom could be beckoning. The two had petitioned the Supreme Court to declare that the law that put them on death row was unconstitutional. The two are convicted of murder and sentenced to the mandatory death sentence as prescribed in the penal code, but they challenged that law, saying that it was unconstitutional, and the Supreme Court agrees with them.
The mandatory nature of the death sentence, as provided under Section 204 of the Penal Code, is hereby declared unconstitutional.
The Supreme Court judges also declared that the suspects in capital offences cases, which include murder, attempted murder, treason, robbery with violence, and attempted robbery with violence, be allowed to address the courts before they are sentenced.
We cannot decipher the possible rationale for this provision. We think that a person facing the death sentence is most deserving to be heard in mitigation because of the finality of the sentence. We are of the view that mitigation is an important, congruent element of fair trial. The fact that mitigation is not expressly mentioned as a right in the Constitution does not deprive it of its necessity and essence in the fair trial process.
At the same time, the court has issued new guidelines that will determine just how capital offences convicts should be sentenced.
We are providing guidelines with regard to mitigating factors which are applicable in a rehearing sentence for the conviction of murder. Those mitigating factors are A, the age of the offender, B, being a first offender, C, whether the offender pleaded guilty, D, the character and record of the offender, E, the commission of the offence in response to gender-based violence, F, the remorsefulness of the offender, G, the possibility of reform and social readaptation of the offender, and finally any other factor that the court considers relevant.
The ruling, while outlawing the mandatory death sentence, the court maintains that the death penalty still stands. This despite the fact that the last time Kenya executed a death row convict was in 1987, when 2 treason convicts were hanged. Since then, different presidents have been commuting the death sentences to life sentences. The last commutal was last year, when the president commuted sentences for 2,747 death row convicts. But even that life sentence was the subject of this petition, and now the Supreme Court reckons this should be relooked into.
Find the comparative jurisprudence with regard to the indeterminate life sentences compelling. We find that a life sentence should not necessarily mean the natural life of the prisoner. It could also mean a certain minimum or maximum.
The ruling will come as a relief for those on death row, as they can now move back to the High Court for a second look at their sentencing. The onus is now on the legislative arm of government to move with haste and enact laws that will give life to this ruling that has been hailed as a critical judicial moment in the country's history. Brenda, Wanga, NTV, Nairobi.